Dear friends and supporters of the Käte Hamburger College, Recht als Kultur, ladies and gentlemen, con Maurizio Ferraris e Angela Condello abbiamo già avuto degli studiosi illustri del diritto romano qui al College. Daniela Bifulco, quindi, è la benvenuta qui per continuare questa tradizione da una punta di vista neapolitana. The question of religion as a source of law in a secular state, in secular states, states, as one could say, freed from religion, even that kind of formulation is disputable, at first glance seems to be a contradiction in itself. Daniela Bifulco, fellow at the Käte Hamburger Center for Advanced Study in the Humanities Lawyers Culture since October 2015, however, is pursuing this very question in her research project in order to do justice to the complex and ambivalent relationship between law and religion in liberal democratic constitutional states. It is, as you know, not only about the factuality of interferences between the spheres, law and religion as such, but also a discussion for the foundations of our normative semantics, how to speak about this relationship. And one could say that some key concepts of law and the state are, as Carl Schmitt suggested, perhaps nothing else than instances of the secularization of religious concepts, or can they be derived and explained in a manner based on something else that some of us call reason, for example? We are curious to know your answer, dear Daniela, to this question. It seems to be strictly bound up with our understanding of the concept of secularization. There is a great debate about it. Most of us have been touched by those questions, and it is difficult to find out a way of this jungle. State-church separation is one kind of expression. State neutrality, very often even the systems of the German system and the French system are mixed up, though they are very and clearly very differently defined and situated. So there is really a lot of reason for debate. And the question is whether this means that non-secular bodies shall not exercise secular power and vice versa, secular bodies shall not exercise ecclesiastical power, or how will we define this kind of separation of the spheres, or the wall of separation? Another metaphor. We are in the field of metaphors when we don't know exactly what it is about. And they are sometimes, however, very helpful. Churches and state differences and separation lines, and also methods and procedures to define the respective realm of law and religion, they do differ. But in a concept of an ideal kind of functional and also spatial sometimes and meaning oriented differentiation, the public sphere should be neither religious nor anti-religious, but a-religious, as you propose, if I understand right. Still, the relationship between democratic liberal constitution, secularism and religion remains sometimes uncertain, ambiguous, and asking for much more clarification. I would like to attract your attention to a recently published booklet within our publication series, Law and Culture with Klostermann, under the title of Recht und Konfession, Konfessionalität im Recht. That's of course not identical to the question of religion and the law. It is another aspect of confession cultures and their relationship even to the differentiation question. And there, for example, traditions in the Catholic field and in the Protestant field differ sharply. Daniela has announced that some of the ambiguities and uncertainties in contemporary constitutionalism, legal thinking, and hence in judicial decision-making depend on conceptual misunderstandings related to the idea of secularization. Although this idea has proven itself to be a powerful conceptual paradigm for understanding modernity and Western societies, a certain Weber had an influence on that. Whether disenchantment really means exactly secularization would be also a point of debate, I would say. So, in any case, legal thinking has often had the tendency to use this paradigm, the secularization paradigm, quite uncritically. Hence, its tendency to take for granted that all significant concepts, and I'm quoting from your presentation, the Schmittian sentence, all significant concepts of the modern theory of the state are secularized theological concepts like sovereignty, human dignity, progress, history, and even, and there of course our heart becomes very much touched by that, if even the notion of normativity would be impregnated by some theological way to think. But if I remember well the debates we had during the Durkheim conference, we were very close to such an understanding that exactly normativity is related to the sacredness of society as Durkheim had seen it. So it will be interesting to see what could be else a foundation of a modern, not religiously founded state and legal order, legal system, and whether your proposition to think in terms of reason, of modern reason, would be the way out of all these problems. But this would mean at the same time that we had to say goodbye to the concept of civil religion, perhaps. And I really would be very interested to know how you're doing this. Because it would mean we must discuss the need for a concept of a civil religion that from Rousseau on, by way of Durkheim and his late student Robert and Bella, is thought to be functionally dispensable, not indispensable, when thinking the modern state. This would be interesting. So I have to present her a little bit. Everybody knows her from our smaller circle in the learning community, as we like to call it. But for those who are not so familiar with Daniela Bifulco, I may recall some elements. She received her PhD, so what is rather normal, but the thesis topic is interesting, on fundamental social rights at the University of Trento. She's associated professor at the Seconda Università degli Studi di Napoli, where she teaches comparative public law. So, interestingly enough, also, she's an active researcher at the Institut des Études sur la Justice à Paris, where Antoine Garapon is its director, if I see right and remember well. Professor Bifulco has lectured on legal interpretation, judicial ethics, and the independence of the judge in Germany, in Italy, à Paris, as well as on legal iconography. Another topic, though she goes into abstraction more and abstractness of reason and reasonability. Secularism, hate speech, and also another interesting and I think very important topic for you is Holocaust denial, discourses, speeches, and people who are thinking this way. Once again, one comes back to the question of the sacredness of such memorials, because one could argue that the remembrance of the Holocaust also may lead to a kind of a secularization of the Shoah. I tried to argument and to bring arguments in this direction in Durkheimian studies some 10 years ago. So she worked as a legal expert for the Council of Europe, and you have been a visiting scholar at Yale Law School and at the Center for Interdisciplinary Research at the Faculty of Law at Tel Aviv University. And then, and to our great pleasure and not really astonishment, but to really our great joy, since October 2015, you have been a fellow, and you are still a fellow at the Käte Hamburger Center for Advanced Study in the Humanities, Law as Culture, and we are so thankful for the continuous creative and innovative input into our, as I said before, small and sometimes becoming larger and larger being learning community. So thank you very much for being with us and having had such a lot of patience with my introduction. That should be a very short one, but you are too important. I couldn't be that short, as you asked me before, because she said, you must know, don't talk about too much about me, because no, that's really, I'm just Daniela Bifulco, that's all, but it is much more.
It's too much.
Okay? So,
Thank you. Thank you so much, Werner, for this warm welcome. Delighted to be here to discuss with you this issue, this topic about law and religion. Moreover, in this Max Weber room, so I'm feeling the burden of a certain responsibility. The topic, my talk and my topic is a very demanding one, and since it has to do not only with the relationship between state and churches and religions, but also somehow with the attitude, with the behavior of the state towards religion, freedom of religion, and freedom from religion, atheism, if you want. So it is a topic that has to do with ultimate questions. That's why it's not only a demanding topic, but also a very heavy stuff. Therefore, I prefer to start de-dramatizing my topic, quoting one of my favorite heroes, Woody Allen. I found this quotation in a very serious book, Ronald Dworkin's last book, Religion Without God. The joke is the following. When Woody Allen was told that he would live on in his work, he replied that he would rather live on in his apartment. This is I'm ready to subscribe it. It was, for me, for my research, a lucky coincidence that almost in the same moment, both Ronald Dworkin's and Hans Kelsen's last book, Secular Religion, have been published. These are the Hans Kelsen's Secular Religion. He wrote it in 1964, but has been published just a few years ago. Please notice that the original title was Religion Without God, and it's exactly the same title that Dworkin chose for his last book, Religion Without God. Two very interesting books concerning law, science, religion, and ultimate questions. Dworkin died a few months later after having written down the essential frame of the book. And Kelsen, who lived on for some years, 9 years, nonetheless did not write another book after this one. So the Secular Religion was his last book. So apparently legal scholars either die or quit writing after having studied this topic, and I hope that what I called a lucky coincidence, the fact to having found these two books will not bring me bad luck. So both these books are relevant for the problem of defining religion, definition of religion, which sometimes become a very taxing, daunting question in the field of judicial decision making, in the field of law in general. And the problem of defining religion and defining secular, the concept of secular and secularism as well, for legal or constitutional purposes, are further questions or issues which lurk in the title I have chosen for my talk. Kelsen argued in his last book that no concept of religion can go without an idea of a personal God, whereas Dworkin makes the opposite point, that religious feelings are possible even without any metaphysical belief in a God. So if you apply these two completely divergent theses to the legal treatment of religion, the scope of religious freedom becomes much broader following Dworkin, of course. The legal implication of one, the Kelsenian approach, or the other, the Dworkin approach, are dramatically divergent. Let me say that Dworkin's approach found its way in the field of judicial decision making, both in the US and in Europe, in particular in the jurisprudence of Strasbourg court. And now I would like to show you a second joke, less funny, more bitter, but very helpful for the second part of my talk. Even for the understanding of the Strasbourg jurisprudence for some judicial cases decided before the European Court of Human Rights in Strasbourg, cases related to the difference between religion and atheism, or between religion and anyway other expression of thought, such as atheism or political convictions or pacifism and so on. So bear in mind the next joke and do not underestimate it, since later it will display, later in the second part of my talk, it will display its heuristic value. It is an Irish joke. And the joke is the following. Two men in Northern Ireland in a pub, one is a journalist, and an Irishman asks him, are you a Catholic? A journalist making researches about this, the tough religious issues in Ireland. So the journalist asks him, the Irishman asks the journalist, are you a Catholic or a Protestant? Neither, replied the journalist, I'm an atheist. The Irishman, non-content with his answer, put a further question. Yes, but are you a Catholic atheist or a Protestant atheist? I found this joke repeated by Richard Dawkins' The God Delusion, and so bear the joke in mind, not the Woody Allen, the Irish joke, because it will be important to understand how Strasbourg Court followed exactly this path. Did not distinguish, at least, between atheism and religion. And so, after this brief relief, no more jokes, unfortunately, let's suffer together, and let me briefly explain the structure of my talk, which is the following. The premise. I will underline very briefly, I have no time to explain everything, the genealogical link between Enlightenment and constitutionalism. I mean, the Enlightenment, the constitutionalism is premised on the separation between the realm of faith and the realm of reason. Then this is the premise. Then I will contradict myself in the role of the devil's advocate, and I will highlight that although constitutionalism is premised on enlightenment, although there is a wall of separation between, in theory, between churches and state, there are nevertheless a number of constitutional provisions and judicial cases which are completely at odds with my own premise. So I will try to go further in a quite counterintuitive way, I would say. My point is that in order to reconcile constitutionalism, this premise, Enlightenment constitutionalism, with religion and secularism, legal scholar, law, legal thinking should make an effort in this direction, in the following direction. That is, looking at the concept of secularism as to a legal concept. I dare to say a positivist concept. Even better, as to a fundamental constitutional principle, such as democracy, equality, pluralism, and so on. So the idea is to look at secularism as a pure, normative, legal, positivist tool deprived of religious ancestries or remnants. In other words, what I'm trying to do is more or less to neutralize, and this is a very, you could say, ideological point of view. I'm trying to neutralize a high controversial ideological concept, such as secularism, and trying to read it, interpret secularism as a self-referential norm. As a constitutional basic principle, of course, valid only, which can be valid only in those states which accept, in a less or more or less explicit way, the idea of secularism. So the idea is, I try to emphasize that secularism, meant as a legal principle, positivo principle, derives its legitimacy from the law, just from the law, and nothing owes to other fields of knowledge. So in a very Kelsenian spirit, I would say, I'm trying to direct myself towards, let's say, a pure theory of secularism. And this was the structure. Now, I go in medias res and explain, and will try to explain the title of my talk, Religion as a Source of Law in the Secular State. The talk focuses on the relationship between constitutionalism, secularism, and religion. So the issue here is whether it is possible or not to reconcile secularism, constitutionalism, and the persisting presence of religion in Western societies. Perhaps it is worth just saying a few words about the idea, about the meaning of constitutionalism. I'm referring here to a quite conventional understanding of the term. Meaning by constitutionalism theory or ideology premised on two essential tenets, that is, the separation of powers, the three powers, judicial, executive and legislative power, and the protection of the fundamental rights. So constitutionalism as meant in the French Declaration, the Revolutionary Declaration of 1789. Any society in which reads as follows: any society in which no provision is made for guaranteeing rights or for the separation of powers has no constitutions. without these two constitutions, a state is not a constitutional state, is something else. So my answer to the question I asked myself in the title is a negative one. Is a negative answer, and I'll try to provide, to give reasons explaining both the title I've chosen and the reasons for my negative answer. I think that the answer must be a negative one because of the existence of a principle, of a basic principle in contemporary constitutionalism, that is the principle of separation of state-churches, or to borrow an image, a metaphor, used by Thomas Jefferson in 1802, there is a wall of separation between state and churches. Jefferson here is referring to the First Amendment of, which is on the right, the First Amendment of the American Constitution, of the U.S. Constitution, which protects at the same time the freedom of religion, the freedom from religion, so the negative aspect of freedom of religion, and also creates this idea, somehow this idea of wall of separation through the so-called Establishment Clause. Indeed, the Establishment Clause, when the First Amendment says that Congress shall make no law respecting an establishment of religion, this is the Establishment Clause. This clause prohibits the government from passing legislation to establish an official religion or preferring one religion over another. And in doing so, of course, it creates the idea, at least, of the separation between churches and state. So I think that the First Amendment of the U.S. Constitution is a good starting point, since it is a very secular provision because of this clause, although the United States is a very religious country. So in a nutshell, the principle of separation between church and state, which later came to be known as secularism, laicité, can be phrased in the following terms. This is a quote by Hungarian legal scholar Sajó. I don't know if the pronunciation is right. Sajó. Non-secular bodies shall not, religious bodies shall not exercise secular power, and vice versa, secular bodies shall not exercise ecclesiastic or religious power. A few centuries before, John Locke wrote, all the power, the same thing. All the power of civil government relates only to man's civil interests, is confined to the care of the things of this world, and has nothing to do with the world to come. This is the letter concerning toleration by John Locke at the end of the 17th century. So the wall of separation between state and churches implies, therefore, I would say, an attitude of reciprocal self-restraint. This means that civil government, state, shall not interfere with the religious beliefs and practices, as long as these beliefs and practices do not interfere with the public order, with the democratic order, and so on. For example, the state is not allowed to suggest or even to impose a definition of religion and belief. On the other hand, wall of separation means that religious communities will refrain from interfering with political power, will not try to dictate their religious agenda to the political power. The next two articles give us an idea of the way the separation between state and churches, where the idea of separation was translated in legal provisions at the end of the 18th century. We already saw the First Amendment of the U.S. Constitution, and there is also this very important Article 10 of the Declaration, of the French Declaration of Human and Civic Rights, claiming that no one may be disturbed on account of his opinion, even religious ones, as long as the manifestations, blah, 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 as I said. Please notice the subtle French irony lurking in this adverb, even, no, which sounds really like a last-minute concession to religion, or opinions, even religious ones. So if it is true that a wall of separation between civil government and churches has been imagined and implemented somehow, and if it's true that this wall of separation is not just an option, but rather a necessary condition for the constitutional secular state, one might also argue that constitutionalism exists okay, there is no that constitutionalism exists only where political powers do not ground their public affecting decisions on transcendent concerns. So the as I told you before, the point I'm supporting here is that constitutionalism is premised on enlightenment, both from a historical and an ideological standpoint. Add to this that constitutionalism and enlightenment shared also the same philosophy of history, which is a philosophy of progress. By this I mean that both constitutionalism and enlightenment share the same perception of time, a time progressing towards the future, and in this perception human beings are conceived as the makers, the only makers of the evolution, of the progress. It is important, I think, to bear in, this is the way Kelsen put it, the idea of the idea of progress and the philosophy of history of enlightenment. So I think that it is important from the constitutional standpoint to bear in mind that this philosophy of history, this idea of progress, which were developed during enlightenment, have no theological implication, have no theological ancestries. Kelsen bothered to write a book, a 400 pages book, to confute, to dismantle the analogies between this idea of progress and the Christian and Hebrew faith in a final fulfillment. He claims that the 18th century philosophy was not a translation of the Christian eschatology, was not a secularization of the messianic belief in a second world to come, but rather a conviction that the future would be much better than the past and the present, thanks to the engagement of mankind in this direction. Here we have some, and I will not comment this because it could take too much time, some example of constitutional provisions where this attention for the future, the care for the future, emerged together with the issue of the protection for the care for the future generation, which has become, as you know, a very popular issue also in contemporary constitutionalism. So we have plenty of examples of this kind of attention for the future in constitutions. Okay. Contradictions. Now I will start I will start to contradict myself. Avoiding Hobbes. Unfortunately, I have no time. So, if everything is so clear, you might ask, so well defined by this wall of separation. You might wonder why I am asking my question again. Because I'm asking my own question, because unfortunately, black and white does not fit. Secularism does not fit constitutional law as well. As I said, the relationship between secularism, religion, and constitutionalism remains uncertain, although constitutional law insists on secularism and on the possibility of a reason-based polity. So in order to highlight some of these uncertainties and inconsistencies, I have selected a few constitutional provisions and judicial cases. The constitutional provisions I have selected tell us something about the indecision of our founding fathers concerning the place religion deserves in the constitutional democracies. And the most bizarre cases are, in my understanding, constitutional provisions of states which are definitely secular, although the text does not explicitly mention secularism as a fundamental principle. And I'm referring here to German basic law, Canadian Charter of Rights, and US and some constitutions of the member states of the United States. Also, so consider the preamble of the German basic law, which starts with the following words. You know the German preamble. Anyway, conscious of their responsibility before God and man, inspired, the German people have adopted the basic law. So this is the preamble of the Grundgesetz. Canadian Charter of Rights and Freedom, which is one of the documents comprising the Constitution of Canada, begins with this phrase: Canada is founded upon principles that recognize the supremacy of God and rule of law. Then, so the idea is that for Canada, for example, human rights are not self-evident, are not a sufficient basis for the law. So should we consider these preambles as if they were positive source of law? Of course, preambles are valid, are source of valid law. They express indeed the fundamental values of a given community. But what about the reference to God? What does it mean? Some scholars say, okay, of course, for example, the German preamble does not directly place the Constitution under the will of God. It is not an advocatio Dei. It is just an invocatio Dei. Whereas an advocatio Dei, such as the Irish one, Constitution of Ireland, the Republic of Ireland, this is an advocatio Dei which place directly the Constitution under the will of God. In Greece, we have a similar preamble. Other example. In the Constitution of 8 member states of the US, Maryland, South Carolina, North Carolina, 8, non-believers, atheists, or agnostic people are explicitly disqualified for office, are excluded from holding any office in the civil department of those 8 states, although the Bill of Rights of the American Constitution, as we saw, begins with the acknowledgement of freedom of and from religion. It may be interesting recalling that this exclusion of atheists from civil government, from public administration, is to be found also in a passage of John Locke's letter concerning toleration. Okay, this is Constitution of Texas, some example. This is Locke, the famous letter concerning toleration. Locke writes in this passage, lastly, there are some exceptions in his idea of tolerance, this Catholic papist and atheists, according to Locke. Lastly, I'm quoting Locke now, lastly, those are not at all to be tolerated who deny the being of God. Promises, covenants, and oaths, which are the bonds of human society, can have no hold upon an atheist. The taking away of God, but even in though, dissolves all. And we can find the same idea in a project of the Carolina Constitution written by Locke himself. This is a project. No man shall be permitted to be a freeman of Carolina that does not acknowledge a God. So the idea here, according to Locke, being that those bonds, covenants, and oaths which allow society to plan for the future and to coordinate political action are threatened by people who are not ready to swear, who do not feel bound to a religious oath. The assumption here, apparently, is that atheists are cheaters, unreliable people, since they refuse to swear and to pronounce a religious oath. Although, by the way, these ideas are completely at odds with the liberal views expressed by Locke in his letter concerning toleration, I tend to sympathize with him and think that he couldn't do otherwise than writing such an idea, given the political situation of his time, given the fact that he was asked by his government to cooperate, and given the fact that the House of Commons in 1666 had in mind to adopt a bill prohibiting atheism. So, this is the working at the end of the page. In the book I quoted a few minutes ago, the working writes, no one who called himself an atheist could be elected to an important office in America. And I think this is probably true not only for the US. In Italy, until 1981, we didn't have any prime minister who was not a Catholic. So the first non-Catholic prime minister was in 1981, Spadolini, then Craxi a few years later. Same in the UK, but in UK we have an established church, so it is quite logical. But anyway, it is also very interesting studying the UK system, where constitutional conventions and stages have been made to ensure that particular and very important political functions, such as those of Prime Minister and Lord Chancellor, are not discharged by a Roman Catholic or a Jewish person. The last sentence on this slide is by a very famous German scholar, Böckenförde, and it is known among the legal scholar as the Böckenförde dilemma. Böckenförde writes, the libertarian secularized state lives by prerequisites which it cannot guarantee itself. So, apparently, this dilemma, the Böckenförde dilemma, is coming back not even from the roar door, but from the main entrance, the preamble of constitution, of some constitution, or the constitution of the 8 member state I quoted. So it is as if to exorcise the danger of fascist form of government to preserve democracy. Law, state, democracy apparently is not enough. So far, Böckenförde is completely right and I'm totally wrong. Now, after having highlighted some contradictions concerning the constitutional provision level, I shift to the judicial level, to the law in action, to the life word or Lebenswelt. My starting point, my starting question, religion as a source of law in the secular states, arises also from the observation of reality. It is a fact indeed that over the last decades, constitutional democracies are facing a huge religious diversity, which is tied both to multiculturalism and immigration, but also to the evolution of the religious phenomenon itself. namely to the shift in the religious perception from a theistic, transcendental perspective to forms of religious consciousness that stress the immanence of meaning in the natural order. In a funny and witty commentary to this shift in the religious perception, in the religious thought, Lawrence Tribe, a prominent legal scholar, American legal scholar, wrote that the British biologist Sir Julian Huxley spoke for many contemporary American religious thinkers when he said that God is beginning to resemble not a ruler but the last fading smile of a cosmic Cheshire cat, the cat. In order to face this dramatic increase of religious diversity, courts, namely the US courts, but also the European Court of Human Rights in Strasbourg, have had the tendency to define religion, the concept of religion, quite broadly, taking a very expansive view of the definition of both religion and belief. Already in 1944, the US Supreme Court ruled that religion must be defined from the believer's perspective, since excessive judicial inquiry into religious belief may constrain religious liberty. In other words, the Supreme Court, the US Supreme Court, held that beliefs and religions are, in other words, the Supreme Court has emphasized the believer's own perspective and the profile of the sincere belief. On the right side of the slide, there is a divergent opinion about what religion is supposed to mean in Kelsen view. Now, in this Western scenario of religious diversity, the question of whether and how people have a right to constitutional protection of their religious freedom has triggered an intense legal and judicial debate. A very significant part of this debate concerns the relationship between religion and culture, which sometimes become, in the court's reasoning, an analogy or even an equivalence. Very telling are the cases about religious symbols, such as the crucifix, that sometimes has been interpreted by judges as a religious, first and foremost as a religious symbol, sometimes as both a religious and cultural symbol, sometimes the religious original meaning of the sign, of the symbol, of this crucifix fades, and the crucifix becomes, in the court's reasoning, a mere symbol of cultural identity. An example of this overlapping interpretation of a religious symbol, overlapping because it is interpreted at the same time as a religious and as a cultural symbol, is the Lautsi case, decided before the European Court of Human Rights a few years ago. The case started in Italy. This is Tar Veneto pronunciation. Started in Italy when Mrs. Lautsi, an Italian by Finnish origins, asked the school board of the public middle school attended by her 2 children for the removal of the crucifix from their classroom, being that symbol in contrast with her secular values. Following the school board's refusal, she challenged the decision before the Italian administrative tribunal Tar Veneto. The Tar Veneto denied Mrs. Lautsi request, ruling that the crucifix is not merely the symbol of Catholicism, is the symbol of the Italian cultural identity. And the Consiglio di Stato, on appeal, confirming on appeal the Tar Veneto decision, ruled that it would be something of a paradox to exclude a Christian sign from a public institution in the name of secularism. One of whose distant source is precisely the Christian religion. Now, the rationale here is that secularism has no conceptual autonomy as a legal principle, since it derives from Christianity and is bound with Christianity to an extent that can legitimate any kind of analogy and equivalence between what pertains to religion and what does not. Therefore, religious symbols such as the crucifix becomes a symbol of cultural identity, even a distinctive sign of secularism, according to the Italian courts. This example is related to what I wrote in my abstract, namely the tendency to use the secularization paradigm, which is a sociological, philosophical, if you want, concept, quite uncritically. In this decision, Lauzi, the principle of secularism, indeed, is deprived of its normative autonomy and is considered just as an idea we inherited from Christianity. Of course, secularization meant as a historical process has much to do with Christianity. I'm not denying that. Nor I'm denying the relevance of the secularization paradigm in the sociological field, which is a very important paradigm. I'm just saying that over the centuries and the decades, secularism has gained a normative, autonomous meaning, being indeed from time to time defined by courts as laicità, state neutrality towards religion, separation law religion, equality of religion of churches before the law. So I think that this is my point, that this normative meaning should work for itself. Likewise, other fundamental basic principles, constitutional principles such as democracy, equality, and so on. And should not derive its secularism meant as a constitutional principle should not derive its content from the secularization theories, which are very important, very interesting, but are some other thing. Don't look at me. You're getting angry. So I'm probably, as I told, trying to neutralize the concept of secularism, transforming it into a scientific legal term and reading it in a positivist grammar. Unfortunately, the arguments developed by the Italian courts in the Lauzi case, unfortunately, they found their way to Strasbourg, although under slightly different terms. This is the Strasbourg court pronunciation about the same case. Although it is undeniable that this is the Strasbourg court, the holding, although it is undeniable that the display of a sign like the crucifix ends up with giving preponderant visibility to the country's majority religion, its exhibition is not sufficient to denote a process of indoctrination. After all, a crucifix is an essentially passive symbol. Mysterious. Sounds mysterious. So, I have many other cases, but I will just propose you a glimpse to the. No, this is very interesting, but I have no time. To this decision by the US Supreme Court about religion, another bad example of a decision about religion and secularism, the so-called Hobby Lobby decision, named for the chain of craft stores that brought the case, decided 2 years ago, 2014. The premise, the Obamacare requires firms with more than 50 employees to provide insurance that includes birth control coverage. And in Hobby Lobby decision, a closely divided 5-4 majority, a closely divided US Supreme Court ruled that corporation, it is really the holding, I'm summing up the holding, corporation have right to religious freedom. Not only individuals, not only groups, but even corporations. So rule that corporation with religious owners cannot be required to pay for insurance coverage of contraception. More precisely, the Supreme Court held that for-profit corporations that are closely held, that is, tiny corporations, such as a family corporation or a trust, fine, not a big corporation, not a multinational. For-profit corporations that are closely held can refuse, on religious ground, to pay for legally mandated coverage of certain contraceptive drugs and devices in their employees' health insurance plans. Now, Hobby Lobby was a for-profit corporation, a secular corporation, but the court held that because the owners of Hobby Lobby held a sincere religious belief that certain forms of birth control caused abortion, they could deny employer paid insurance coverage for them. In so ruling, this is a very interesting decision for many aspects, not only for religion. For example, because the court in so ruling embraced the view that tiny closely held corporations are legal persons under a certain status, the Religious Freedom Restoration Act, and therefore are capable of exercising freedom of religion. Now, please go back with your memory to the Irish joke, which is connected with this jurisprudence, Article 9 of the European Convention on Human Rights. Very often it happens that atheists, unconcerned agnostics, want to regulate their relationships with the state on the basis of the same legal constitutional proceedings provided by Constitution for regulating the state-church relationship. This is quite a paradox. And the Irish joke may be helpful to highlight this paradox. Strasbourg, the jurisprudence, paved the way to a weird approach to atheism, which is exactly the same approach of the Irishman asking the journalist, are you a Protestant atheist or a Catholic atheist? Indeed, the Commission, both the Commission, European Commission, before a certain moment, before 1998, and then the European Court of Human Rights have repeatedly considered that the word belief in the Article 9, Section 2, freedom to manifest one's religion or belief. So both the Commission and the European Court repeatedly considered that the word belief must be understood in a broad meaning, and that this word belief covers any ideological conviction. So in its constant interpretation, the court ruled that religion is not restricted to common or traditional religions. Both traditional religions and a variety of Christian denominations, as well as Buddhism, Hinduism, Judaism, Druids, atheism, Scientology, and so on, were presumed by the Commission to be religions or belief. As the court pointed out in this very famous case, freedom of religion is also, look at the last sentence, is also a precious asset for atheists, agnostics, skeptics, and the unconcerned. So in this view, religion becomes a container in which the autonomy and self-legitimacy of the atheistic, agnostic, skeptical thought fades, thus becoming a subset of the broader category of religious thought and conscience. From now, I'm almost done. I have 5 minutes, Werner.
You have even 7.
7, even 7.
Or 10.
Okay. Now I will read. Otherwise, I would read a few pages. So you can sleep now. No, otherwise I'm not finishing. In cases like this, the subjective profile of freedom of religion, that is, who has the right to enjoy freedom of religion, becomes entangled, tied up with the objective side of freedom of religion. That is, what does religion mean for legal purposes? In this or similar situation, law, namely courts, and courts are obliged to face a persistent theoretical dilemma, which can be phrased in the following terms. Does the ambition of defining religion and belief go beyond the principle of state neutrality in religious matters, given that the secular constitutional state should avoid taking position on the definition of religion because of the wall of separation, and given that the substance of religious truth, according to Locke, Hobbes, Kant, among others, so given that the secular state should avoid taking position on the definition of religion, how far is the state, the civil government, supposed to go in defining religion? To what extent does a secular state have the power and legitimacy to define religion and distinguish religion from the concept of belief? Ideally, because of the wall of separation, the secular state should not interfere and not defining religion at all. But if we only look back at the text of Article 9 of the Human Rights Convention, we are obliged to find a different answer. We are obliged to say that law, courts, must distinguish between religion and belief. Why? Because the text, section 2, freedom to manifest one religion or belief. The text itself makes a distinction. Although the text doesn't add any other further indications concerning this distinction between religion and belief, nonetheless, it tells us that such a distinction exists. Whereas from the individual perspective, individual believer's perspective, such distinction, religion, belief, probably is not a meaningful one, yet the distinction has been made in the text, in the wording of the article, and should inform the decision-making of the court. Indeed, courts have the job of applying the broad terms of Article 9, broad, to specific cases, and for such application to be consistent and clear, some type of definition is required. So I couldn't think of a better answer to those asking why the legal scholar should intrude in a philosophical issue such as defining religion to legal purposes and distinguishing religion belief from non-religious belief. But the idea of distinguishing between religious and non-religious beliefs, asking, are you a Catholic atheist or a Protestant atheist, makes no sense. Nonetheless, the Strasbourg court made exactly this decision, claiming that belief covers any ideological conviction, and thus squeezing into the text, into the scope of Article 9, any kind of, let's say, secular belief. Of course, the court is also forced to do that because the court is receiving claims on the basis of Article 9. So the court, for legal reasons, cannot say, look to the claimant, look, there is another article, Article 10, freedom of expression. So the court is obliged to answer to the question. So if Article 9 is a good way to answer the claimant or not. Anyway, in my opinion, the most problematic aspect emerging from the Strasbourg Court on Article 9 is the equation between religion and philosophical political beliefs. That is, the most problematic aspect is the acceptance by this jurisprudence of politically, ethically motivated claims as belief rather than expression of thought or conscience. Take the case of pacifism. The case is Arrowsmith versus United Kingdom. The case of pacifism that has been accepted by the Strasbourg court as a belief even when not linked to a particular religion. Take the case of two cases concerning neo-Nazism and fascism behaviors. In these cases, quite ancient, the Commission, not the court, the European Commission, avoided to make clear up whether some political beliefs, such as Nazism and fascism, fall within the concept of religion and belief under Article 9. In doing so, every action that a person takes or position that a person upholds, which is traceable to an ultimate belief, would seem to be religious. And the difficulty with this kind of idea is that this kind of reasoning tends to turn everything into religion. So, just to end, I will end with another my final point. These examples, Article 9 of the European Convention, show perhaps that clarify that the decision of the decision of leaving the question of defining belief and religion basically unsaid and unanswered, without distinguishing the concept of religion from the concept of belief, political belief, ideological belief, and so on, has not only not helped to clarify the meaning of the wording of provisions such as Article 9 of the European Convention, but also has increased the conceptual confusion in this area. Following Kelsen, we may say that this confusion derives from the tendency to find parallelisms between problems of jurisprudence and problems of theology. The confusion about these two fields is very telling in the Lao Tzu case, I think, as I try to tell. And so we owe to Kelsen's last book a powerful theoretical effort aimed to criticize the unproblematic use of analogies between religion and different fields of knowledge, such as social theory, politics, and philosophy. Although Kelsen himself was aware that the search for parallelism in the question raised in these different fields is not illegitimate, is not an illegitimate scientific task. Nonetheless, he tried to demonstrate that the transformation of heuristic analogies into a thesis about the permanence of a historically secularized substance is not only illegitimate but misleading and dangerous. Take the case of the analogy between the sovereignty of the state, interpreted as omnipotence of the legislator, and the omnipotence of God, Carl Schmitt. The analogy, in Carl Schmitt's word, the analogy turns out to be an identity. Take the case of the analogy between person and corporation, Hobby-Lobby decision. Take the case of the interpretation of human dignity in German basic law, Article 1. Human dignity, some scholars claim that human dignity in Article 1 of German basic law is a concept which hints to the secularization of the idea of God himself. The idea being that since God made humans in his own image, human life is somehow sacred, holy, too. So accepting this parallelism, one can jump to the conclusion that human dignity has to be protected since it is sacred, since it is holy. No euthanasia, no abortion, no self-determination would be possible anymore following this kind of parallelism, which Habermas described very well. No, he's not saying that, but describing this parallelism between the idea of human dignity and the idea of a translation of human dignity from the idea of the secularization of God. Also, Ulrich Haltern wrote about that, very interesting things. So the defense of modern reason and the autonomy of science advocated by Kelsen in his last book is very close in spirit to Hans Blumenberg's defense of the legitimacy of modern age. I'm quoting the two of them because they were crucial, very important for my conceptual frame of my topic and my speech. There is, I think, a red thread tying these two works, these two authors, Kelsen and Blumenberg, although Kelsen did not quote Blumenberg in his Secular Religion. And so if we walk along this red thread, the framework for a critique to the secularization thesis will be provided. And I'm closing, I'm finishing. What I'm referring to here is not, more precisely, a critique of the sociological concept of secularization, but rather a critique, as I said a few minutes ago, a critique of the way legal thinking legal scholars, courts, handle sometimes this concept of this sociological concept of secularization. That is, uncritically, as if it were a taken for granted objective reality rather than what it is, just an interpretation, just a theory, a very interesting theory, but it is just an interpretation. So the legitimacy of modernity and the autonomy of law from science and and the autonomy of law and science from religion and theology should be, I think, emphasized, bearing in mind the possibility to relinquish, to jettison, to get rid of not of the theory of secularization, but to get rid of its uncritical translation into the grammar of legal thinking. This may be the path to follow in the attempt to finding a valid reply to the Birkenforde dilemma, according to whom the libertarian secularized state lives by prerequisites which it cannot guarantee itself. These preconditions are to be found, I think, in the self-assertion of modern reason, in the way Hans Blumenberg designed it, and in a theory of a knowledge, legal knowledge as well, which at no point makes use of a divine point of view to legitimize itself, as Kelsen suggested. And the way I'm trying to the path I'm trying to walk through foresees a use of secularism as to a legal constitutional fundamental principle deprived of religious ancestries and translated in a language that should be aseptic and cold as only the legal language can be. Fine.